We'd like to welcome everyone to the seminar, and it's a special pleasure to welcome people from around the world. Michael and I right now are in Spain, and so it's great to have old and new members with us. There's been a lot of debate about the role of the Supreme Court, and it's not just an issue in the United States, it's an international issue. And so we want to broaden the discussion today to say, do Supreme Courts help or hurt democracy? And look at the particularities of different countries, different governments, and explore the issue. So we have with us, to help kick off the discussion, three people who have thought very deeply about this issue. Nicholas Bowie, a professor at Harvard Law School and an award-winning teacher of constitutional law, and a historian whose research focuses on critical legal theories of democracy in the United States. He recently testified before President Joe Biden's commission on reforming the Supreme Court. Justice Luis Alberto Barroso has served on Brazil's Supreme Court since 2013, where he was nominated by President Dilma Rousseff. An internationally renowned scholar, he has lectured at universities around the world. Larry Tribe, a university professor and professor of constitutional law at Harvard, has taught at the law school since 1968. He's widely recognized as the most influential scholar on US constitutional law in our time. So Nico, start us off.
Hi, everybody. Thanks so much for inviting me. It's a pleasure to be here and to be part of this international conversation. So the question put on the table is whether the Supreme Court helps or hurts democracy. And I can only speak right now to the United States Supreme Court. And I think answering that question with respect to the US Supreme Court first requires an understanding of the various things that the US Supreme Court does, as well as some definition of democracy. So the United States Supreme Court does three basic categories of things. The first is that it reviews the constitutionality of federal laws. So when Congress passes a law that limits or bans Chinese immigration, the Supreme Court asks whether Congress has the power to do that, and if so, whether it has or whether it violates any of the limits in the Federal Bill of Rights or other limits within the Constitution. The second thing the court does is it interprets and it enforces federal laws, including laws that hold the president or other executive officers accountable. So for example, one of the questions in Trump versus Hawaii a few years ago, when President Donald Trump imposed a ban on travelers from Muslim majority countries, one of the questions the court considered was whether that executive action violated a statute in addition to the Constitution. And the third thing the court does is it reviews whether state laws are preempted by either the Constitution or federal law. So in the United States, there is a federal system. Each state has its own legislature and its own Supreme Court, but states are inferior entities relative to the federal Constitution and federal law, which the federal Constitution makes supreme. And so when a state passes a law, if it conflicts with a federal law passed by Congress or conflicts with the US Constitution, the Supreme Court will invalidate the state law. So it does three things. It reviews federal laws, it enforces and interprets federal laws, and it reviews state laws. So putting those three things aside for a moment, then the next question is, well, what is democracy? To see whether those three things help or hurt democracy. And I personally follow Danielle Allen and Elizabeth Anderson in defining democracy as the pursuit of political equality. So not elections, not just is there a vote at some point in the process, but I think of a democracy as a community in which everyone has equal power to shape community decisions, to decide community issues. I think of democracy as an ideal as opposed to something that has been realized by the United States or elsewhere. And putting that ideal of democracy as the pursuit of political equality next to the three things that the court does, I think one of the things the court does is highly objectionable, and the other two are more ambiguous, but are leaning toward hurting democracy. So the ways in which the Supreme Court's actions can help or hurt democracy, I think there are sort of two ways in which you can think of it. One is on the merits. So when the Supreme Court issues a decision, does that decision compromise or suppress political equality, or does it enhance it? So you can think of a decision that enfranchises people as helping democracy, or a decision that disenfranchises people as harming democracy or hurting political equality. And then the second consideration is the decision itself accountable to some sort of democratic body? So when the Supreme Court makes a mistake, how can the democratic demos, our population, reverse that mistake or say, sorry, you got this wrong. We think that more people should be allowed to vote than your decision allows. And from that perspective, I think the Supreme Court's review of federal law, so the first thing that it does, is highly objectionable on both dimensions, in that it hurts democracy. So this idea in the United States is known as judicial supremacy. It's the idea that the Supreme Court's interpretation of the Constitution is supreme relative to Congress. And a good illustration of that, perhaps the best recent illustration of that, is a decision from 2013 called Shelby County versus Holder, which reviewed the constitutionality of one part of the Voting Rights Act of 1965 as amended, which for the first time allowed Black people throughout the nation to vote on equal terms as white people. And when that decision was, or when the Congress first passed the Voting Rights Act in 1965, it was operating under an amendment that specifically gave Congress the power to enact appropriate legislation to give life to a prohibition in the 15th Amendment that banned discrimination on account of race, color, or previous conditions of servitude. So when the Supreme Court first reviewed the Voting Rights Act, which among other things limited the power of states to pass restrictive voting laws, the Supreme Court asked, is this appropriate? That's the textual question the court considered. Is the Voting Rights Act appropriate? And even though Congress had never passed a law like that before in all of its dimensions, the court looked at the Constitution and felt, well, who is to decide what appropriate really means in this context? When we reviewed literacy tests and poll taxes and other laws that restricted the right to vote, we did not think that those laws themselves violated the Constitution every time they were enacted. But when we see this law passed by Congress in 1965, we do think that it is appropriate. And so in decisions starting in 1965, the Supreme Court held that Congress did have the power to enact the Voting Rights Act. But 50 years later, in Shelby County versus Holder, the Supreme Court reversed its decision with respect to a regime known as preclearance, which allowed federal courts as well as federal executive officers to review particular state laws to see if they violated the Voting Rights Act before they could take effect. And the Supreme Court essentially held, we no longer think that 50 years later, this is appropriate. We think that Congress has exceeded its limits, and the Constitution does not allow Congress to restrict the ability of some states to pass voting laws, even though the restriction is to protect the right to vote of people within those states. So I would regard a decision like Shelby County as anti-democratic on the merits, in a sense that the end result was a proliferation of state laws that suppressed the ability of all people to vote on equal terms. It was a decision that invalidated Congress's ability to protect the right to vote. And I would also regard it as anti-democratic in terms of the court's own accountability, because the decision that reversed its own precedent, that reversed what Congress and the president thought was constitutional, was a 5-4 decision of the Supreme Court. So a majority of the Supreme Court thought Congress lacked the ability to enact this sort of law. But what that meant was that 5 justices had the same power to decide the constitutionality of a law as majorities of Congress beginning in 1965, presidents who signed the law, and even majorities of the Supreme Court that had upheld the law before. And so what judicial supremacy reveals for me is that these 5 people, or a slight majority of the US Supreme Court, effectively has the power to determine what the nation as a whole is allowed to do, subject to a constitutional amendment. And the United States Constitution happens to be one of the most difficult to amend constitutions in the world. It requires supermajorities in 2 houses of the federal legislature, as well as 3/4 of the state legislatures, all of which, except for Nebraska, are also bicameral, which means to get an amendment through requires a tremendous amount of work, whereas the Supreme Court could just reverse its decision by another 5-4 vote in the future. So I think of the court as itself not a democratically accountable institution. The only form of democratic accountability comes in the confirmation process when members of the Senate weigh in on whether a president's appointee, and the president who picks Supreme Court justices, whether they should serve on the court. But once they're on the court in the United States, Supreme Court justices serve for life. They are subject to impeachment, which has never been successfully carried out of a Supreme Court justice, in part because it's such a difficult process. And they can be reversed only by a constitutional amendment, which itself is an incredibly difficult procedure. And what it suggests is, if you're trying to interpret the fundamental law of the United States and figure out what can the country as a whole do, the decision is not up to the American people deciding in elections who they want to represent the country. It's not even necessarily subject to Congress and other elected officials. It's subject to a majority of vote of 5 unelected officials who in turn can change their mind according to their own discretion. It's a form, I think, of domination by undemocratic actors. And so on the merits in terms of its institutional role, I think of decisions like Shelby County as being highly harmful to democracy. And Shelby County is not alone. It's not as though Shelby County is this once off. But if you look at the history of the Supreme Court's review of federal laws, dating back to the first major invalidation of a federal law, Dred Scott versus Sanford in 1857, which held that Congress could not ban slavery in federal territories. A lot of decisions are like this, where the Supreme Court has struck down federal laws that created income taxes, the Voting Rights Act, laws that were designed to promote political equality, while at the same time, the court tolerates federal laws that might inhibit political equality, like the Chinese Exclusion Act or the internment of Japanese Americans without regard to whether they were loyal or not. So all that's to say that I think on the first thing that the Supreme Court does of reviewing the constitutionality of federal laws, the net effect is pretty harmful. The number of decisions that on the merits I would regard as supporting political equality are few and far between. The most recent is probably a decision from 2012 in which the Supreme Court held that Congress could not define marriage to include only a man and a woman. Rather, Congress had to defer to the states. And then in the subsequent decision, the court held that states could not ban marriage equality. On the other 2 things that the Supreme Court does, which I'll just mention briefly, I think whether the Supreme Court hurts or harms democracy is a little bit more ambiguous. So the Supreme Court, in addition to reviewing the constitutionality of federal laws, also interprets them and enforces them. It takes a statute and says, what does this statute say? Let's enforce it. And I think on that level, the court has gone in various different ways. So very recently, just this past June, the court interpreted the Voting Rights Act, the same law that it partially invalidated in 2013. And it restrictively interpreted it in a decision involving the Secretary of State of Arizona, Brnovich. And it restricted it to the point of insignificance, which is we do not think that the statute means what it says. I think that's really harmful, and it can be as harmful as striking down a law on constitutional grounds. Some of the worst Supreme Court decisions in Supreme Court history, like United States versus Cruikshank, where it held that Congress could not punish a lynch mob that murdered hundreds of Black people in Louisiana after the Civil War, can be just as devastating as a decision striking down a law. But it's also really difficult to imagine a government in which a court does not interpret its statutes. And in this respect, if Congress or the legislature disagrees with the court's interpretation, in theory, Congress can reverse the Supreme Court's judgment by just passing a new statute, even though the United States has a very difficult legislative process. But there are also decisions that have interpreted federal laws expansively to promote political equality. And so in that respect, I think on the merits, it's a little bit more ambiguous than the court's review of federal law. And in the final dimension, the court reviews state laws to see whether they're preempted under federal law or under the Constitution. And I think that history is also ambiguous for roughly the same reason. When the Supreme Court reviews the legality of a state law, it doesn't present a conflict between just 5 justices and a legislature, because usually when the Supreme Court reviews a state law, it's in the process of enforcing a federal law. So after the Civil War, during Reconstruction, Congress passed a law that invited the Supreme Court to review the constitutionality of state laws on the ground that states were using their laws to discriminate against recently freed Black people. And that law still forms the basis for a lot of the most famous Supreme Court decisions ever, like Brown versus Board of Education, or Roe versus Wade, or Obergefell versus Hodges, which banned racial segregation and legalized abortion and banned and promoted marriage equality in the most recent decision. And so I think the problem there is when Congress cannot amend or reverse the Supreme Court's decisions. But again, it's really difficult to imagine a legislature in a federal system that lacks the ability to ensure that the lower legislatures, like state and local governments, comply with its laws. So in short, the Supreme Court, I think, does 3 things. It reviews the constitutionality of federal laws, which I think is highly anti-democratic, and it enforces federal laws against presidents and states. And I think that's more ambiguous on the merits. But the real problem is this form of judicial supremacy, where when the Supreme Court weighs in on a decision, there is no democratic actor that can hold the Supreme Court and say, we disagree with you. We think that you're not promoting democracy. We want to do it better. In the United States, the only way of reversing the Supreme Court's decision in that respect turns on the amendment process. And the amendment process has become so difficult that it's difficult to imagine future amendments, at least without a huge crisis ahead of time. So that's just the introduction, I think, to the question of whether the Supreme Court in the United States, at least, harms or hurts democracy.
Thank you. Thank you very much. It's a pleasure to be here. And I don't totally agree with the arguments that have been made by Nico, and now I'll try to explain my point here. I made 4 topics. I will try to summarize very briefly Nico's views. I'll make a couple comments on them. I'll give my own perspective of what constitutional democracy is, and then I will try to show why I think that judicial review, including of federal legislation, is still very important worldwide. So I'd say I tried to summarize Nico's views in 3 ideas, basically. First one, that the Supreme Court, throughout its history, made several mistakes, and it delayed, to a certain extent, the advance of civil rights. That's one of the points he makes. The other point he makes is that history shows that one of the characteristics of the Supreme Court throughout the years was protecting the wealthy and the status quo. He makes this statement very clearly. And also he says that there's no reason to suppose that the Supreme Court, that the justices would do a better job than elected officials in interpreting the Constitution. And after stating these premises, he says that the Supreme Court should not be treated as the guardian of democracy. I think that's, sorry if I misunderstood some of your points, Nico, but I think this is a very brief summary of some of his ideas. Well, I'll briefly comment on them to say that from Dred Scott to Citizens United, it's impossible to deny that the US Supreme Court has made many mistakes, as courts all over the world, I should say, Nico, including mine many times. Perhaps, and they've made some serious mistakes, perhaps a little less serious than the mistakes that have been made by the executive and by the legislature. So this is one first point I would like to raise here. Second, it's undeniable, as you say, that the Supreme Court or Supreme Courts worldwide are composed of intellectual elites with at least some kind of connections with the status quo, with this political establishment. But I would say not invariably. That's not an absolute rule. In the United States and in other parts of the world, I would say, the Supreme Court has been instrumental in advancing rights of women, of Afro descendants, gay rights, and in some parts of the world, in the protection of indigenous peoples. So I won't deny that the Supreme Courts quite often express the views of the dominant class, but that's not invariably. And the third comment I'll make is that for many reasons, I think in many situations, constitutional courts and Supreme Courts can do better constitutional interpretation than the political actors because they are not moved by the short-term demands of politics. Not being elected, which you highlight as a problem, sometimes is the solution for taking reasoned decisions, not populist decisions, not decisions that are compelled by the demands of short-term politics. So my conclusion about your thoughts is that judicial review is not mandatory for a democracy, but it has been very useful. In most countries in the world, most democracies in the world, after the Second World War mainly, they have all but 2 or 3 or a handful of countries, they have all adopted some sort of judicial review. And I think this is something that we should pay attention at. That was the choice. Even countries that adopted parliamentary supremacy until the Second World War, as most countries in continental Europe, they moved to the American way of doing constitutional law, which is having a court of justice with the role of reviewing any kind of legislation. I don't make any important distinction between federal and state legislation. We can go back to that. So these are my first comments on Nico's points. I would add, Michael, if I may, constitutional democracy is the fusion of 2 concepts, as we all know, constitutionalism and democracy. And constitutionalism meaning limited power, rule of law, and protection of fundamental rights, and democracy meaning popular sovereignty, universal suffrage, and rule of the majority. As we all know, and Larry has wonderful pieces on this matter, there might be a tension between the rule of majority and the protection of rule of law and of fundamental rights. And most countries in the world have reserved this important role of being the arbiter of this tension, has reserved this role to the Supreme Court or to constitutional courts, because the 2 main roles of a Supreme Court are protecting fundamental rights and protecting the rule of law. And I think we can find many examples throughout the world history of these 2 roles being decisive. I would give as examples in the United States, decisions in cases like Brown versus Board of Education. And I think there is, and I've read some criticism relating to Brown, saying that it didn't produce a real immediate impact in reality and that it took over a decade until the civil rights movement would make any difference. But I think that's an unfair criticism, because I think Brown brought this discussion of racial segregation to the radar of society, to the mainstream of debates, and it helped push history in the right direction. And I don't think this should be disregarded. Decisions like Loving versus Virginia for interracial marriage, like Roe versus Wade for women's rights, and United States versus Windsor and Obergefell for gay rights. And to finish this part of my intervention, in Brazil, the Supreme Court in the past, especially in the past, well, since the redemocratization in 1988, we've held important decisions protecting women, supporting affirmative action for Afro-Brazilians, defending gay rights, defending Native peoples. That would never be done through Congress, never. And we're trying to push the abortion, the decriminalization of abortion through the court. It's very difficult. Brazil is the Catholic Church is very powerful. And in the past couple of years, Nico, in Brazil, the Supreme Court has been decisive in constructing like a trench or a wall to protect democracy against a very populist and authoritarian leader. And we've been striking down many of his measures. And in what regards the pandemic, since the president was in total denial, it was the Supreme Court that took most of the decisions, allowing local and state governments to take measures, prohibiting a campaign, summoning people to go back to the streets and go back to the work when the whole world was recommending social distancing. In protecting Indian communities, the court was decisive in doing that. And even the preparing of a vaccination plan was a court order in Brazil. So the court has played a very decisive role in protecting democracy and in protecting people's health and lives in Brazil. And the last thing I'd like to say, and that I now close, someone could say, well, maybe in a country like Brazil or in other parts of the world, judicial review is a good thing, but it should not be universalized. But I would not agree with that either. And I think many progressive American scholars are frustrated that the Supreme Court took a conservative turn in the past decades. And so they're trying to develop new theories to fight this. And so I think it's a more strategical behavior than actually good constitutional theory. So these are my comments, Michael, to start the debate. I want to say that I really appreciate reading Nico's points, and he makes them in a very brilliant way. And I've had discussions similar to these with who was that? Mark Tushnet, Jeremy Waldron, people that also have criticism to judicial review. So it's really an intellectual challenge to be here discussing this with a scholar like Nico. And thank you for the invitation.
Great. I'm tempted to press Nico on some of these points to see if he can reply. But first, Larry, over to you.
It's a great pleasure to be here with Roberto and Nico. Nico is one of my favorite former students. And when he testified before the President's Commission on the Supreme Court of the United States, on which I also have the privilege of serving as a member of that commission, I couldn't have been prouder or more impressed by Nico's views, with many of which I find myself in agreement, not all. There's a section of my treatise on constitutional law, which I think, if I don't forget it, was called 2.5 Chairs for judicial review. And I do think we should distinguish judicial review from judicial supremacy. It is Nico's thesis, not so much that judicial review is fundamentally anti-democratic, but that judicial supremacy, although there are instances that he will readily concede, many of which Roberto has also spoken about, in which the American Supreme Court has done things that are praiseworthy from any pro-democratic perspective. It's his thesis that judicial supremacy is on the whole unjustified, that it's done more harm than good. I think there is a good bit of truth in that. People like me who sort of grew up during the era, the kind of Camelot period of American constitutional law, the Warren years, the Brennan years, we're accustomed to thinking of cases like Brown versus Board of Education, the desegregation decision, as illustrative of what the Supreme Court and its supremacy in elaborating the Constitution could do, somewhat redeeming it from the terrible errors of cases like Dred Scott and others. But Nico points out importantly that even those decisions, even Brown, is really an example of Congress protecting equal rights. It was an act of Congress passed in the wake of the Civil War, the Ku Klux Klan Act, that provided the legislation that was invoked by the children who wanted to attend integrated schools. And it was enforcing that act of Congress that the Supreme Court was engaged in Brown versus Board of Education. But I don't think we can get very far by simply enumerating, as though we were weighing on a scale, the decisions which on the merits are terrible and anti-democratic and those that are pro-democratic. I think we have to both disaggregate the concept of democracy into a number of components and make some generalizations that cut across these individual decisions. And to do that, I created a kind of chart in my own head, which I asked Michael and Piku to put up so that I could guide people through a discussion. Kelsey, if you could put up the list of things that occurred to me. I call it 9 dimensions of democracy. And some of them, I think, are particularly relevant to some of the points that Roberto was raising. In particular, number 9, the rule of law. It's true that democracy as an ideal is about the pursuit of political equality. But unless we have stability, neutrality, and predictability and universal applicability of rules of law, notions of equality are far too mushy and far too unstable to provide much solace, much comfort. And with respect to preserving the kind of baseline of the rule of law, apex courts like the Supreme Court of the United States or the Supreme Court of Brazil, even though one can criticize them for being politically unaccountable, are important in preserving this 9th dimension of democracy. It is their very lack of political accountability that enables them to advance and preserve the rule of law. Indeed, it is the lack of accountability that allows them to do some of the most dramatic things that both the Supreme Court of Brazil, you can take that chart down just for a moment, that allows both the highest court of Brazil and our highest court to do some of what both courts have done in the protection of women, in the protection of gay rights. The decision of our Supreme Court in validating state laws that require married couples to consist of a man and a woman in the Obergefell decision, that would never have happened without our Supreme Court. the invalidation by our Supreme Court of the ironically named Defense of Marriage Act, which was a federal law that essentially treated same-sex couples as second-class citizens. That decision would never have been made by a politically accountable Congress. And just to take the most recent example, I certainly agree with Nico about the terrible history of our court with respect to voting and enfranchisement. But to take the most recent example, even a highly conservative, indeed reactionary Supreme Court in the year 2020 prevented our would-be authoritarian president from holding on to power. There were challenges that were brought quite corruptly, in my view, by the Trump administration to the election of 2020. And there were cases pending in the US Supreme Court in which the president of the United States thought that the 3 justices that he had managed to pack onto the court through rather devious means in several cases, that those justices would surely rule in his favor, that the election had somehow been stolen from him. There were complicated, ultimately very weak legal arguments. And if the court had done his bidding, we would really be in a terrible situation in the United States now. We would have had the, if you can go back again, Kelsey, to my little list, one of the important dimensions of preserving democracy, though it can't really be summarized purely in terms of the ideal of political equality, is number 2, ensuring the peaceful succession and transfer of power. Something that a politically unaccountable Supreme Court may be able to do. Our court was one that the former president thought wouldn't prevent him from seizing power. Happily, he was mistaken. On the other hand, our court in the year 2000, in the infamous decision in Bush versus Gore, provided for the succession of power, but not in accord with the operations of the Electoral College properly understood. I guess my main point is that you really have to disaggregate the various roles that an apex court needs to perform in order to decide whether, on balance, it is better or worse to strip it of some of its authority. If, for example, one were to strip the American Supreme Court of the authority to review the validity of state and federal legislation, the decisions of the Warren Court ensuring one person, one vote, equality of representation in all parts of government would not have taken place. They couldn't have happened. On the other hand, we have a severe departure from that 3rd dimension of democracy in the composition of the Senate and in the operation of the Electoral College, neither of which is the fault of our Supreme Court, but both of which are the fault of the original design of the system. You can take down my 9 dimensions again. If people want to look at them later, they can. I guess what I end up saying is that we have a very defective democracy in the United States, less defective perhaps than some countries, more defective than in others. But we shouldn't confuse the responsibility of judicial supremacy for those defects with the responsibility that I think attaches to the original design. We have a constitution built on a profoundly immoral compromise with slavery. Many of the design features of that constitution remain even after the Civil War and the Civil War amendments that profoundly changed the way our constitution operates. To try to imagine what it would be like to extract judicial supremacy by our Supreme Court from that system is extremely difficult. That is, it's so integrated a part of the edifice that it's almost a meaningless question to ask, would we be better off on the various dimensions of democracy if we were to pull that building stone out of the system? It's tempting for the kinds of people that Roberto mentions having spoken with, Mark Tushnet and others, to say that our infatuation with our Supreme Court is simply an anachronism built on how wonderful we thought the court was during the Warren years. We need to get over that. We need to stop worshiping it. That much I agree with. To treat the court as sort of a marble palace, a great temple of justice, and to pretend that it's inherently apolitical is a profound mistake. But to pull it out of the system and to recommend that other nations not give their Supreme Courts the kind of power that I think the Supreme Court of Brazil happily exercises to hold back the authoritarianism of someone like Bolsonaro would be a terrible mistake. So I'm going to limit my opening remarks to that. You can see that they're all over the place, but I'm happy to engage in dialogue about the particulars with Nico, Roberto, and with the interesting people you've assembled for us to discuss with.
Great, thank you, Larry. There's a wealth of themes that we could address, but I want to focus us and put two objections that we've heard, one emphasized by Roberto, the other by Larry. I want to put them directly, Nico, to you. But first I want to say there's something intriguing and even charming and fascinating about the generational and international divide that this topic brings out. That's just an observation. And though I may be on the far side of that generational divide, Nico, I'm leaning in your direction. And I especially, this is maybe because I have a prejudice for bold contrarian views, which you put across beautifully and powerfully. But I want to begin, one other thing. Part of the force of Nico's argument, as I see it, is that it operates at two levels: a principled philosophical argument about democracy and a practical, empirical, historical argument about how judicial review in the United States has actually worked out over the long haul. Now, I'd like to put a challenge to you that Roberto raised, which is of the second kind. It's about the practical, historical, empirical effects of judicial review in Brazil. He's got a pretty powerful point, doesn't he, Nico, when he says that in Brazil, the rights of women, of Afro-Brazilians, of indigenous people, and of LGBTQ citizens have been defended and protected precisely by the judicial review of Brazil's Supreme Court. What do you say to that argument?
Well, so I can't speak empirically to that argument just because I'm not familiar with the history of the Supreme Court of Brazil's role with respect to those advances. My disciplinary background is in history, and so I'm most familiar with American history, but so I can speak to that with respect to the United States and see if we can come up with some generalizations, if that's responsive, Michael. So,
no, but assuming he's right about that,
yeah.
What does that do to your argument?
Well, it suggests that part of my argument is contingent. And so there is a theoretical level to it, but there's also a contingent level. And I think that for me, again, as a historian, what I draw from the contingencies and chances and things that did not have to be this way in the United States is I draw some guidance for what that could mean for the theory. So Roberto, you brought up Brown versus Board. And so the way I think about this question of the Supreme Court or judicial supremacy with respect to anti-discrimination is to just ask the question, So in the United States, can Congress enact an anti-discrimination law or an anti-slavery law? So before the Civil War, that question, can Congress enact an anti-slavery or an anti-discrimination law, that was the subject of political debate. So representatives, senators from the North and South just disagreed with one another. And in part of that disagreement was constitutional. So some members of Congress thought we lack the power to ban slavery west of the Mississippi. Some members of Congress thought it should be subject to popular sovereignty of people in territories and states, or white people, white men, to decide whether slavery would exist. But it was like the political debate. And the major legislation before the Civil War tends to go by the name the Compromise of, because it reflected this constitutional disagreement that was then temporarily resolved in legislation. So the Missouri Compromise of 1820 said that slavery would exist south of the Missouri's southern border, or the Compromise of 1850 allowed California to come in as a free state while other states had, while the Missouri Compromise line disappeared, or the Kansas-Nebraska Act. Like, all of these reflect this question of, can Congress actually ban it? And so in Dred Scott in 1857, it closed the era of compromise. Noah Feldman, my colleague, just wrote a book about the end of the compromise constitution in which this comes up. In Dred Scott, the Supreme Court said, we're interpreting the Constitution, and we think the interpretation of the Constitution is that Congress cannot ban slavery in the territories. Nowhere, not north of the Missouri Compromise line, nowhere. And so when Abraham Lincoln read this opinion, he ended up campaigning for president on the platform and part of rejection of judicial supremacy. That if we allow the Supreme Court to make the final word on what the Constitution allows us to do, we are not run by a federal government of elected officials. It's not your voting that matters. It's just the decisions of this unelected body that determines what we are all allowed to do. The language is something like, we have ceased to be a government of the people, but have handed to that eminent tribunal the power to decide what we as a community are allowed to do. And after the Civil War, when the Union won and slavery was outlawed with the 13th Amendment, Congress proposed constitutional amendments in part to take the decision out of the court's hands. So the 14th Amendment not only guaranteed civil rights for all people born in the United States, but also included language saying that Congress had the power to enforce these articles by appropriate legislation. So Congress did it. Congress enacted a civil rights law. It enacted several civil rights laws, including one in 1875 that banned discrimination in public accommodations. It said it is a crime and it's a civil offense to not serve someone in a theater because of their race or previous condition of servitude. And when the Supreme Court reviewed that law, despite Congress's new amendment that gave it this power to enforce this by appropriate legislation, the court said, we still think this is not constitutional. We think that Congress lacks the power to ban racial discrimination. Congress has some new powers under the new amendments, but not that one. When the Supreme Court reviewed a civil rights law that gave Black people the power to sue in federal court to vindicate these new constitutional rights, in cases like Giles versus Harris, in which the court reviewed an Alabama constitution that effectively disenfranchised all Black people in the state, the court said, we don't think that we have the power to interfere with Alabama in this respect. And so I agree with Roberto that Brown in 1954, so almost a century later, does represent this vindication of this view of the Constitution. But in some ways, Brown is just correcting the Supreme Court's earlier mistakes. And these are profound mistakes in which the court inhibited and specifically banned Congress from doing anything about segregation as it spread in the wake of these Supreme Court decisions. So Brown is not simply this counter argument or something on the other side of the scale to suggest that sometimes the court allows for segregation, but sometimes it bans it. It's that up until Brown, the Supreme Court had effectively banned the rest of the federal government from doing anything about all of these segregation laws and Jim Crow laws and lynch mobs that were spreading throughout the South. And so while I agree with Larry completely, as well as Roberto, that the 20 years afterward changed the discussion around the court, that, oh, it turns out the court can actually do some good when it interprets the Constitution. More recently, it suggests that that 20-year period was really something of an exception that proves the rule, in the sense that the court has returned to that previous era in which the court has held Congress lacks the power to pass anti-discrimination laws, to pass things like the Voting Rights Act. And so what I think is important about that story, the most important thing is, can Congress enact an anti-discrimination law is not a legal question. It's not as though the answer turns on the legal definition of appropriate. It's a political question. It's a question that had divided the United States for decades before the Civil War. That was in part the subject of the Civil War, that continued to guide the United States' politics after the Civil War, and that continues to guide questions about the right to vote today.
Okay, Nico, all right, so far we've been discussing the empirical, practical, historical effects in the United States of the Supreme Court exercising judicial review the way it has. And it could be that if your argument is entirely historical, insofar as it's historical, you might say in the United States, there are a whole lot of mistakes. It's done more harm than good. But you could also say that in the case of Brazil or in some other country, after you look at that historical record, you might say, well, they've done more good than harm, therefore judicial review is a good thing there. But I heard your argument as being, I want to move now to your argument of principle, theory, and come to a counter argument that Larry made, when Larry said it's precisely the lack of political accountability of justices that preserves the rule of law. And so the question I'd like to put to you here is, do you think the rule of law is of value independent of the democratic considerations of political equality and accountability to the demos that you mentioned, or not?
Yeah, I think the rule of law is valuable, but I think the question is, the rule of law of what? What is defining the rule of law here? So in response to the empirical argument about what the court's role has been in the United States, I think it presents the question of, well, why, theoretically, would you give the Supreme Court the final word about whether a law is appropriate or not? So like one answer is because you think that the justices are just going to be more in tune with like justice when it comes to determining what is appropriate or what is due process or anything else. But while I of course agree that justices may not be bound by the same exact electoral considerations as elected representatives, I think the judges are political actors. They're appointed because of their relationship to the majority party. Like, it's not as though President Biden is going to appoint any random person to the Supreme Court, or even just someone who, has gone to the best law schools or has the best education. I would assume he would appoint someone who shares his political views, his ideological views, or his approach to constitutional interpretation, because that's the obvious move here when the court is determining what the legislature and the other branches are allowed to do. And so when it comes to like, what is the rule of law? I think the rule of law as defined by federal statutes matters a lot. I completely agree with Larry and Roberto that we don't want a system in which authoritarian leaders can go off and do whatever they want and undermine elections and everything else. But I don't think that the answer, though, is that means we need to have this unelected body totally determining everything we can do, as opposed to enforcing statutes that have been passed by previous administrations that are subject to future amendment in a democratic process. The problem I have with the US Constitution in particular is it is so difficult to amend. If we had a constitution like the United Kingdom, which is basically built on custom and statutes, then the Supreme Court's holding that the Constitution prohibits Congress from doing something would not present much of an objection, because the legislature could just change the Constitution. And so I think Roberto's right that lots of countries around the world are turning to the US model of judicial review, but notably in countries that have followed the sort of Commonwealth model, like the United Kingdom, New Zealand, Canada, they still maintain legislative supremacy. They still allow the legislature to disagree with the court about its interpretation of what the Constitution requires. And I think that that model would work very well here. And so the rule of law does not mean the Constitution as written, hundreds of years ago, nor does it mean the Constitution as interpreted by the court. The rule of law can mean, what do we as a people and our elected representatives think the Constitution demands? And that can change over time. That interpretation can change just as the court's interpretation can. But I think it's a category error to say that the court's interpretation of the Constitution defines the rule of law, as opposed to the court's interpretation of a federal statute, which could also define the rule of law, and which I think is more consistent with democratic accountability.
So Roberto, what Nico is saying, if I understand him, is that what he's against is judicial supremacy, meaning that the Supreme Court, a Supreme Court, should not be able to strike down, to invalidate a law passed by Congress or the Parliament under conditions where the Congress or Parliament can't turn around and say, no, we override what the court just said. That's really what Nico is against. Do you disagree with that, Roberto?
Yes, unfortunately, I do.
Okay.
I do agree with many of the theoretical premises of what Nico says. So we don't have any major theoretical disagreement. But as he mentioned earlier, that many of his arguments are contingent, and I'm trying to make more theoretical and universalizable arguments. I want to say one thing. First, I support constitutional supremacy, not judicial supremacy. And although a Supreme Court has the formal power of saying the last word, it does not own the Constitution. So the Constitutional Court interpretation must take into account other political actors, other branches of government, civil society, meaning that the Constitution is not what I want it to mean. I need to listen to other important actors in this drama. And secondly, unlike the United States, in many countries of the world, it's not so difficult to overrule a Supreme Court decision by a constitutional amendment. I know it's very difficult to amend the US Constitution, but in Brazil, I can give you a handful of examples in which Congress overruled a Supreme Court decision. And that's considered a legitimate institutional dialogue between the courts and Congress. That's one point I want to make. As for the importance of courts in protecting democracy, Michael, Nico, and Larry, and everyone, if we watch what's going on in the world, we will see how decisive is a Supreme Court or a constitutional court. Because the first thing Viktor Orbán did in Hungary was to diminish the power of the Constitutional Court and pack it. And that's what happened in Poland. And that's what happened in Turkey. And that's what happened in Venezuela. And that's what just happened in El Salvador. That means that throughout the world, there's this general perception that the Supreme Court or the Constitutional Court is a barrier to authoritarian leaders. And I think that we must emphasize that. And finally, Michael, and most part of our audience is American, there is, on my perspective here, a strong influence on the way scholars, progressive scholars, are seeing constitutional jurisdiction, as we say, or judicial review, as you like to say. The lack of perspective that the court will become progressive anytime soon is determining the way many progressive American scholars are seeing judicial review. And I, would like to remember that whatever you do in the United States in what concerns the Constitution, constitutional interpretation, and judicial review will affect the world. So if you weaken judicial review in the United States, no doubt that that will be used to legitimize weakening Supreme Courts and constitutional courts throughout the world. So Nico and Larry, please add this concern to our many local, to your many local concerns about this. These are the comments I would make, Michael.
Great.
Can I say a word before we go to the general discussion to both Nico and Roberto? I agree very much that speaking about the rule of law without focusing on what the law is rather abstract and unhelpful. But much of the law is concerned with the rights of individual human beings against the group, whether it is the right to equal treatment, to equal dignity, the right to religious or political expression. And the notion that Nico describes, and I think makes unattractive just in the very description of it, that it is up to these 9 individuals simply to make decisions for all of us, needs to be offset with a notion that was most eloquently expressed, I think, by Justice Robert Jackson in the famous case about making school children recite the Pledge of Allegiance to the flag, where a majority of the people of West Virginia and of many American states would have wanted to say that you can discipline a child for not joining the group and pledging allegiance to the flag and expressing loyalty to the United States of America. But when the Supreme Court said that you cannot force a child to pledge allegiance to the flag, to salute the flag of the country, Justice Jackson, in response to the idea that a mere majority of the Supreme Court ought not to impose its will upon what the people as a whole want, responded that it is the whole point of a Bill of Rights to preserve individual autonomy and claims of the individual from the vicissitudes of the mass, of the political majority. It is not really an unmitigated virtue to say that the people of the United States, through their representatives in Congress, favor something, and therefore a mere 9 people serving for life ought not to be in the position to prevent them from achieving what they want. What they want may be to impose a uniform definition of whom you can love upon the minority that might have a different view. And that's why I think decisions like Obergefell and Loving against Virginia and West Virginia Board of Education v. Barnett, the case involving the mandatory flag salute, are an important offset to the undemocratic, deliberately undemocratic, in the sense of majoritarian rule, role of the Supreme Court of the United States or of any Supreme Court. So I would hesitate before moving from the conclusion that our Supreme Court has done more harm than good to the conclusion that we would be better off in the long run by disempowering it in important respects.
Can I just add one point in direct response to that?
Okay, sure, yeah.
I think it is notable that that case, West Virginia versus Barnett, is another case enforcing the Ku Klux Klan of 1871. Yeah,
No, I agree. That's important.
And so, but what I think it suggests though is like majorities too care about minority rights. That
sometimes
countries without judicial supremacy, like the United Kingdom, are not known for just trampling on individual rights. The United Kingdom has a very strong regime of protecting property rights and protecting other very important rights from being overridden. And so I don't think that I don't think that the connection between judicial supremacy and the protection of important rights follows. And so for me, I think Congress can also protect rights. Legislatures also protect rights. And even though legislatures make mistakes, just as courts make mistakes, we're not going to create a system of government without government mistakes. The question is, what should we do to protect against those sorts of mistakes? And I think empowering the court to have the final word is not the best protection as much as enhancing democracy and making it easier for everyone to participate in passing laws.
Great. I want to open up the discussion now to the group, and I'm famous for cold calling people, so I'm going to start with Pratap Mehta, a political philosopher coming to us from India, who studied in England and also, of course, knows a lot about the situation in India. Pratap, your thoughts and any questions you want to pose?
There's lots to discuss, but I just wanted to make 2 points. I mean, one is a point about rule of law and the connection between the contingent history and the principle. Because I think one of the strongest arguments in Nico's favor, I think, is the very fact that you can tell this history as a contingent history. So if it turns out, if you ask the question, how do we know which way the Supreme Court will go? Will it protect equality? Will it protect liberty? Will it protect democracy in any of our countries, India, Brazil, the United States? And the answer to that turns out to be a very contingent one. Well, the Warren Court might go this way, the Roberts Court might go this way, the Indian Supreme Court in the 1980s might have gone one way, now it goes another way. What that actually does to the idea of rule of law itself, because isn't that in some senses conceding that we are conflating the rule of law and the existence of constitutionalism with actually the pronouncements of particular judges? So rule of it's more rule of judges rather than the rule of law, the very fact that you can actually tell this history in this kind of contingent way. My question to, I think, Justice Barroso is the following, which is, so one interesting question to ask is, okay, so what are the conditions under which Supreme Courts are friendly to democracy, and what are the conditions under which they enable the decimation of democracy? And maybe I'm being colored by the Indian experience, where the Indian Supreme Court has gone from being supposedly one of the most powerful institutions in the world to an absolute scandal in the last 5 years on almost every dimension of protection of democracy. It's the same Supreme Court, it's the same formal structure, it's still the same appointments process. And it seems to me that the underlying variable there is the broader distribution of political power in society. That Brazil right now has a, you might say, a much more conflictual distribution of power between the presidency and Congress, and perhaps in terms of the social groups that actually make up Brazilian society. But a country like India, which seems to be heading towards a much stronger majoritarianism, doesn't quite have that opposition space. And so what you see happening is that courts in some senses reflect that underlying distribution of power much more than they actually challenge it. So even cases where it turns out to be the case that the court has, struck a blow for democracy, as the Indian Supreme Court occasionally used to do in the 90s, 80s, and 1990s, in part what enabled it to do that was its reading of a political zeitgeist, that the distribution of power in society is such that you can still strike this blow. But wherever, right, in some senses, a single party, consolidates and so forth, you find the Supreme Court is the first institution to cave. So how much of the Supreme Court is symptom and how much of it is cause of democracy? I guess that's the question, provocation.
Roberto, do you want to reply to Pratap?
Yes, certainly. Well, one thing that we all could agree here, I think Nico, Larry, and myself and the others, is that democracy is more than just majoritarian rule. And I would if I may question, when Nico says that Congress can also protect fundamental rights. It can, but Congress is typically a majoritarian institution. And thus, I would question that it could protect fundamental rights, civil liberties, and human rights, as well as an impartial body that interprets law composed of people with legal training and duties of impartiality. So I don't think we can say that Congress can protect fundamental rights as well as a decent Supreme Court. That's one thing I would like to say. And as for this idea of broader distribution of power, I totally agree. And one thing I think we should stress here, Michael and Pratap, is that countries go through different moments in their history. And if you suppress an important institution like the Supreme Court, or if you weaken it in this juncture, in this context, you might need it right ahead in history. That's why I don't want to make a strategical assessment of Supreme Courts, as I think many progressives are making in America. So the Supreme Court now, it's a hurdle for the progressive camp. So we are going to weaken it for good. I think that could be a dangerous strategy, because you might need it sometime or at a certain point down the road. What I could say, though, especially addressing Pratap questions and remarks, is that you only need a strong Supreme Court when things are not going well, when you need to protect democracy, when you need to protect fundamental rights from unfair attacks. So usually, and I can say that for Brazil, usually if the Supreme Court is a protagonist at any time, it's because something is wrong. It's because politics is not playing properly its role. And so regarding the issue of distribution of power, if a Supreme Court becomes too powerful, it's because the other institutions are not functioning well. And if it becomes too weak, that's also a problem. That means that the court has been subjugated by the other power. So there is a balance here. And as for Brazil, this protagonism of the Supreme Court right now means that there's a problem with the executive and that there is a problem with the legislature. And this should be rebalanced at a certain point.
Could I speak to that? I'm tempted now to agree more with Nico than with Roberto. And it's Pratap's notion of cause and effect that makes me think in these terms. It's not as though we have a continuous ebb and flow and the pendulum will swing one way or the other, and we need to be careful not to act in the immediate present in a way that disregards what we might need in the future. That's all true, and yet some people, and here I include myself, have come to believe that what has happened to the United States Supreme Court in recent years is not simply an incremental move that might move back, but is a self-reinforcing anti-democratic movement that we cannot afford to leave exactly as is. That is, let me just turn the clock back briefly to the time when Justice Scalia died. And the President of the United States at that time tried to fill that vacancy on the Supreme Court and was prevented for a whole year from appointing anyone. Then, as soon as Donald Trump became president, that seat was filled by someone who is extremely far to the right, by Justice Gorsuch. The theory of keeping the seat open was a theory that says in the president's last year, he shouldn't be able to appoint someone. And yet, in the last moments of the Trump presidency, he appointed Justice Barrett, another extreme conservative. And when you add Justice Kavanaugh, we now have a solid phalanx of justices who are not simply going to reaffirm decisions like Shelby County, which stripped Congress's Voting Rights Act of much efficacy. And then they piled on with the Brnovich case, destroying what was left of the Voting Rights Act. And then they said, we can't do anything about partisan gerrymandering. And what it looks like is we have a Supreme Court that is now on an irreversible course that will be self-reinforcing and self-replicating. It's a course that might make it possible for extreme conservatives to put more justices on the court in the future. And unless something is done rather dramatically to change the trajectory, it may well be that this imagined moment when we need a Supreme Court to push back against a failed legislative and executive branch will not arrive, because we have an almost impotent legislative branch. We have an imperial executive becoming increasingly powerful, and we don't really have much pushback from the court. And people who have that view are likely to say that keeping our hands off the court now in order to avoid shaking it up and in order to avoid changing the trajectory on the theory that we may come to regret reducing the court's power, are assuming an historical path that is not likely to come about.
Thanks, Larry. I want to now call on Elena, who is from Brazil, a law student at Yale University. Your thoughts, Elena?
Hi, I wanted to comment on a couple of things from the discussion so far. I think that one thing that Justice Barroso has mentioned that I think is very important is that the history of judicial review in the US is very different than the history of judicial review in other places, and Brazil is one of them, I would say. And I think that, to his point as well, that the justices in the Supreme Court are not absolutely free to make decisions about how to interpret the Constitution as they would like, is true in that there is a Constitution that obviously to some extent limits the range of decisions that they can put forth. And I think that that brings us to a point that is always important in understanding how a Supreme Court works, which is what constitution are we talking about? And the different constitutions in each country have enormous impact on how the Supreme Court has been, I guess, historically in these countries. And I think that in the US has a very particular type of constitution. It's very minimal, it's very broad and general. In that sense, it allows justices to have enormous leeway in trying to define each of its concepts. The Brazilian constitution, as our newest constitution, it is much more specific. There are very specific provisions in it. So it's the job of interpreting it is a different job. And historically, at least in Brazil, from what I remember, and Justice Barroso may correct me on that if I'm mistaken. But I think that historically, the court has had a very, very important role in protecting minorities. And I think that the somewhat nefarious history that the US has had with the judicial review in the past, especially regarding civil rights, is not really the case in Brazil. And I imagine that this analysis would be different in many different countries. And I think that in Brazil, for example, there are several rights, and I think the protection of gay rights and indigenous rights are great examples of moments in which the court has done things to protect minorities that a majoritarian government wouldn't have done. And I think that that is also, it brings us back to a theoretical thinking about the Supreme Court that is, I think the point about rule of law has a connection to the structure of the Supreme Court and how it's built. And obviously, we all know this, the way that justices stay in the Supreme Court for longer than in legislatures allows the court to have a somewhat more stable composition and therefore interpretation of certain provisions, at least theoretically, than a changing political climate. And I do agree with Justice Barroso when he says that it seems very contingent historically that we would say that we don't need a powerful check on majoritarian government. Because all you would need, if there were no Supreme Court, and I'm thinking of Brazil, for example, in this moment, if there were no Supreme Court as a check, then all it takes is one strongly authoritarian government or a deeply perverse majoritarian incentives. And you can think about this in places where there might be a very powerless minorities that could be supplanted by a majority, that the Supreme Court could be a necessary kind of check. So I think, in summary, I think that to think about a Supreme Court theoretically, I think we need to understand that its role has been really different in different places. I do think that the US has a very particular history that obviously is important, but it does not mean a necessary critique on, it may be a critique, but not a fundamental and absolute critique on the institution of the Supreme Court as a form of control of majoritarian governments.
Yeah, thank you, Elena. Now, since the UK was mentioned before, Gwyn, unmute, let's hear your views coming from London.
Well, I think Helena's absolutely right to bring up the context. You know, it's pretty fundamental. You know, as has been mentioned, Britain's constitution's unwritten. It's basically a political institution. And the US Constitution's a legal document, I guess. I commissioned a series of BBC Reith lectures in 2019, delivered by Jonathan Sumption, who had just retired as a justice of the UK Supreme Court. So our relatively new Supreme Court, 2009, had generated quite a lot of controversy because of its role in during the Brexit, well, what can I call it? During the Brexit debacle, if you like, when the government had been pushing through stuff without enough recourse to Parliament. So the newish Supreme Court ruled that the government couldn't prorogue Parliament. Parliament came back. Anyway, so the debate was quite hot, and we generated a bit more of it by getting Jonathan to spill the beans because he just left the Supreme Court. He is himself quite a controversial figure, but let's go into that. Anyway, his theme was the decline of politics and the rise of the law to fill the void. And he argued that in the UK, it was beginning to be the case following America. As has already been mentioned, everyone follows America, so you have a massive responsibility over there. In the UK, the law is beginning to take over the space once occupied by politics. So he said, we expect courts to play the role of Solomon increasingly in every conflict, public or private. And he argued that Britain should learn from the US to be careful about what rights should be beyond democratic choice. Well, we came to Washington to give one of these lectures. It didn't actually go down too well, as you can imagine. But he began this lecture by talking about Tocqueville. So I can just read that sentence. When he came to the United States in the 1830s, one of the things that struck him most forcibly was the dominant place occupied by lawyers in the public life of the nation. And in his classic account, de Tocqueville suggested that lawyers as a class had succeeded to the beliefs and influence of the old landed aristocracy. They shared its habits, its tastes, and above all, they shared its contempt for popular opinion. So, you know, he also quoted Lincoln, who Nico has already quoted beautifully from. So just to think that the conclusion here is that I think active citizenship, feeding a vibrant democracy, is really our best hope for protecting minorities and realizing differences. But even more perhaps relevant is that politics, a functioning political discussion, allows a public debate and allows a public participation and engagement in the issues. So if something's going on at a legal level, it's obscure and people don't catch up with what is actually happening. So it impoverishes the political debate and political engagement. And of course, it's a massive challenge now because all our politics is increasingly rather faltering, alarmingly so. So it's about a political conversation improving, and I think that's maybe where the focus should turn. That's what I'd say.
Kiko, can I throw in something?
Yeah.
Just that it seems to me that if you look at how the British Supreme Court, young as it is appointed, the judiciary here is an independent institution. Its senior figures get together and nominate people for the Supreme Court. They give the nomination to the Prime Minister, who has to take that nomination to the Queen and ask for that person to be appointed. So he has very little role, if any, except for procedural, in appointing the justice. Had we a system like America, where people were appointed by presidents according to, you know, and hopefully you get as many in as you could before your term came to an end, I don't think the Supreme Court here would have any respect at all, because it would be seen as entirely a function of political placement. And that context seems to me to be vital in understanding how a court may behave and from whence it derives its legitimacy.
Thanks, David. I would like to go to Sergio to give us a little context in terms of the Italian situation and the Italian court system.
Well, I'm not as much of an expert as some of our esteemed guests, but my understanding of the underlying question, this debate, is if, in principle, an organ such as the Supreme Court in Italy is called the Constitutional Court, requires a degree of independence from political powers in order to protect democracy. And in Italy, the answer to that question is a resounding yes. for the obvious reasons of why and how the Italian constitution developed in the aftermath of fascism. I want to suggest maybe an objection to that idea and ask if ultimately that question depends on the ways in which we understand the relationship between justice and democracy. If we truly believe that in the idea of the arc of history bending towards justice, and my impression as someone who's not a student of American constitutional law, but my general impression is that there is a tendency to see constitutional law in the US in that sense, in that way, as bending towards justice. Then if we see justice in that way, shouldn't we welcome more political interference into the workings of the Supreme Court? If instead we don't see justice as it relates to democracy in that way, if we see justice as a matter of deliberation, and we see the ebbs and flows of conceptions of justice and the common good, shouldn't we maybe welcome instead a degree of unaccountability as a measure of the independence of the Supreme Court from this ebbs and flows of justice, of conceptions of justice?
Thank you, Sergio. Michael.
Well, Nico, I'd like to pull some threads from this discussion and bring it back to you. And I want to go back to an argument, even a plaintive plea that Roberto made from an international perspective. He said he understands why American progressives are worried about our Supreme Court, but that if we weaken the United States Supreme Court, and I think he had in mind especially if we could somehow get rid of its judicial supremacy, as you would like us to do, that this will have an effect around the world. And as I hear Roberto, he's accepting your account of the litany of mistakes and bad calls that the US Supreme Court has made, but he's saying something big is at stake for constitutional democracy around the world, and that we should bear this in mind. What do you think about that?
I completely agree. And one thread that I noticed through the past few comments is the importance of contingency, which I completely agree with, that trying to come up with a universal rule for courts is probably a fool's errand. But one lesson that I draw from the American experience that I think is corroborated by the experience of other nations is that the combination of judicial supremacy, so there is some unelected, like not democratically accountable body with the final interpretation of the Constitution, and in difficult to amend Constitution, together that creates a really big problem. That is a problem that defines the United States Supreme Court at the federal level. It does not define state Supreme Courts at the state level, but it does define the US Supreme Court at the federal level. And I think that it does not define, as far as I can tell, any other Supreme Court in the world. The combination of such a difficult to amend constitution with judicial supremacy is a pretty unique federal phenomenon. And it's one that the United States has embraced as essential to the protection of rights, despite its uniqueness. It's as though the United States itself has the best track record across the world of protecting individual rights, which I'm sure everyone here can attest is not necessarily true. And so I completely agree with Pratap's view that, when you look at the contingency, so you look at the Brazilian experience that Elena raised, or the Indian experience or the American experience, and you see just these different patterns emerging from both different structures as well as different histories, one question that arises is what can explain it? What can explain why in some societies the court seems to be this necessary actor at provoking the legislature or the government to respond, whereas in some societies the courts are struck down by Orban or other dictators in waiting? And I think the takeaway for me, that a phrase that I agree with, is also been advanced by a scholar at Georgetown, Gerardo Span. I mentioned him in the testimony I gave to the Supreme Court Commission, and he used the term veiled majoritarianism. And I'll just quote from him here. He wrote that Supreme Court justices are socialized by the same majority that determines their fitness for judicial office. The formal safeguards of life tenure and salary protection, which are designed to insulate the judiciary from external political pressures, are not designed to guard against majoritarianism inherent in a judge's own assimilation of dominant social values. And what he meant by that was, in most places where there's judicial independence, which I don't contest as a bad value. So I think I may disagree with Sergio about the desirability of political interference with the court. But judges are still paying attention to politics. So I don't know, Roberto, your social background, but in the United States, most Supreme Court justices hang out with senators and representatives in DC, in the Capitol, and elsewhere. They not only understand the zeitgeist, they're actively participating in it. And I think the best explanation for what is the court going to do reflects the fact that most of these people are Democrats or Republicans who hang out with other high-ranking Democrats and Republicans in Washington, D.C. Brown versus Board of Education can be explained in part by the real embarrassment of people in Washington, D.C. in the 1950s during the Cold War, as the Soviet Union pointed to segregation and said to other countries, look, the United States can't be taken seriously on the world stage. And so even though people in Alabama may not have cared about that, Republicans and Democrats in Washington, D.C. really did. It can explain Loving versus Virginia and other similar cases where elites in Washington may have been in more agreement than the rest of the country. And I think most significantly, it can also explain cases like the Chinese exclusion case, in which the Supreme Court allowed Congress to exclude Chinese immigrants on the basis of their nationality, in part because there was an elite consensus that is fine, that is good. And so to me, what that suggests is that the justices of a Supreme Court cannot necessarily be trusted to be these apolitical, neutral actors whose eyes are closed to the political zeitgeist around them. They reflect it. And so I totally agree with Gwyneth that in thinking of how can we stop mistakes, how can we prevent more Chinese exclusion laws or genocides against Native people, like these mistakes can be incredibly consequential, and no one wants them, including me. I don't want to see minority rights trampled upon. But in thinking of what can we do to make these mistakes or to resolve these mistakes, I think I think it's wrong to suggest that courts are so insulated from political pressures around them that they don't embody some of those political views on the problem. And so I would much rather see an active citizenry constantly mobilized and caring about these issues as political than treating these as legal questions that turn on the meaning of a legal term that only elite lawyers can interpret.
Thanks, Nico. I wanted to pose a question to you and then also to Roberto and Larry. And that is one thing, just not as a legal expert, but as a citizen, that I notice and troubles me is that our Supreme Court nominees, our Supreme Court justices, are life-term appointments. And from my point of view, that seems almost quasi-monarchical. Why in a democracy do we have some people, and this goes a lot along with some of the criticisms and problems Nico raised, why do we have them in for life? Is there a way to retain the institution, but think of it, reforms in it, whether it is to have term limits of the Supreme Court, whether it's, I'm not sure, 7, 10 years, so that you're on the Supreme Court long enough not to be subjected to political pressures by a particular administration. But at the same time, this fateful decision of life terms, that's one issue. Or what is sacred about having 9 people on the Supreme Court? Would the Supreme Court be improved if it was a larger body? So I wanted, Nico, I'll start with you, and then Larry and Roberto. How could the US Supreme Court be improved?
So I'll only speak briefly to just emphasize the international uniqueness of the United States system in this respect as well. So as far as I'm aware, the United States Supreme Court is one of the only Supreme Courts in which there are life tenured judges. And it's also one of the only Supreme Courts in which it has so few judges relative to the population. So as far, I think right now, I completely agree with Roberto that in terms of court packing and term limits, that these are 2 formal or ways of achieving court reform that have become increasing in popularity, in part because of what Larry described earlier with the response to Barack Obama's appointment or nomination of Merrick Garland. That was the Republican majority in the Senate refused to allow. But I do think that these are also just reforms that would bring the United States Supreme Court more into line with the rest of the world that we could learn a lot from. And so while I agree that the other countries may follow the American example, this is one in which other countries have not followed the American example. And I think that was a good move on everyone else's part.
Roberto,
and then Larry.
Okay, I just want to comment a couple of things before I address directly this point, Kito. The first thing is Supreme Courts throughout the world are usually aligned with the majorities. That's an universal rule. And it should be this way. Courts only should be counter-majoritarian in very specific cases. And in fact, corresponding to the expectations of the majority is what gives a Supreme Court the political capital to be counter-majoritarian when necessary. So the fact that courts are aligned with the majorities should be no surprise. That should be the ordinary thing to do. You only should be counter-majoritarian in exceptional situations when that's necessary. And that's true for the United States. I've seen surveys and researches that confirm that. Second, Nico, there are also in Brazil Supreme Court judges that hang around with senators and politicians. It's true, but it's not my case. I would like to add. I receive them when they ask any specific institutional purpose, but usually I don't hang out with them just because I don't think it's proper, and you should keep a distance to be impartial. And one last thing I want to comment before I address what Kito asked is what Larry was describing, and Nico just mentioned all that happened with the appointment of the successor of Justice Scalia, and then the appointment of the successor of Justice Ginsburg, just shows how unprincipled politics can be, how unprincipled Congress can be. And that's one other reason why a principled court can be an important tool in a democracy, because as Rawls like to say, we like to think of ourselves as a forum of principles. And what happened in these 2 examples that Larry mentioned was that they just could not follow principles. They moved by one measure in one case and by a totally different measure in the other case, and we're talking about the same people. To be true, I was shocked how little reaction that brought in the United States. The fact that in one case they said, we can't do it because it's the last year of the presidential term. And in the other case, they did it in a few weeks. And, you know, people just accepted that as normal. And that kind of struck me. And finally, as Kito's question, in Brazil in 1988, when the new constitution after the military regime was enacted, I supported the European model of constitutional courts with a mandate, 10 years, maybe 12 as in Germany. And I've been there for 8 years, people, and it seems like a lifetime. And it's, I think 10 years, 12 at the most, is a reasonable time. This is in discussion in Brazil right now also. But what I've said about this, we follow the US model. What I said about this is worse than not having the best system is having a system that never stabilizes, that you keep changing. So although I favored the European style in 1988, I didn't support the change right now for this reason. But we only have a 33-year-old constitution. So I think in the United States, that could be a valid discussion. And I think it's very important, because one thing that I learned, and we all our professors should consider that. I had a former professor, and he said something that I always kept in mind. He said, a professor every 10 years, he should throw away all his notes, all his cards, and rethink everything all over again. Because after a certain time, you start repeating yourself and you don't innovate anymore, and you're not part of pushing history in the right direction. So although I was not in favor of reopening this discussion in Brazil, I think it's a fair discussion in the United States, because our constitution is 33 years old and yours have more than 2 centuries. So it might be a good time to rediscuss this. And from everything that was said here, I think this is something that could change in the coming future, the profile of the court, without weakening it. So I think this is a fair discussion, Kito, and I would reasonably put it on the table in the US, knowing that if this happens in the United States, the world is going to follow. Most countries in Europe adopt constitutional courts, but Brazil has a Supreme Court, Argentina has a Supreme Court, Canada has a Supreme Court, American style, and it could affect other countries in the world, but that wouldn't be a problem. That wouldn't be a negative change if it happens in the US. So I think appointments with a term, but of course we should be careful, because the Supreme Court needs to have this counter-majoritarian role. So it needs to be a fairly long mandate, at least 8 years and maybe 10 years and 12 at the most. But I think this is a good idea to discuss in the United States, although I was against it here in Brazil, because it didn't pass at the proper time, and I didn't want things to keep changing. But I swear to God, I don't want to stay there for life.
Before, Larry, I would like to call upon you, but to put a very specific question to you. It's in the spirit of what I think Nico most wants, but let me put it as a modest reform. Well, you'll decide how modest, how radical. That the Supreme Court retains judicial review. It retains the power to invalidate federal laws, but Congress can, by majority vote, override that invalidation. Would you be for or against that?
Let me begin by saying that as a member of this presidential commission on the reform of the Supreme Court, there's a limit to what I'm allowed to discuss. The commission heard testimony from about 40 witnesses, of whom Nico was one. We have spent enormous amounts of time discussing, among other things, the Canadian approach that Michael, you have been adverting to. That is the approach in which the Parliament can override a decision of the Supreme Court. That's one of dozens of proposals we have considered. We have considered term limits. We have considered limits of 12 years, 14 years, 18 years. A lot of ideas that sound wonderful in the abstract turn out in implementation to have unexpected problems. Let me just give you one example. If you limit the terms of justices to a dozen years or 18 years, non-renewable, of course, one of the things you worry about is what happens to them after they leave. There's a danger that they will try to please the people whose money and power will influence their post-judicial careers. How do you avoid that? Do you have limits on subsequent employment by Supreme Court justices? Would it take a constitutional amendment to have term limits? As Nico says, our system is so incredibly hard to change by amendment that becomes a reason to worry about proposing something that would essentially be merely a thought experiment. And in fact, as Nico points out, what we have now is really unique in the world. No other country in the world has a court as small as ours, an apex court as small as ours, compared to the volume of its work and the size of its population. No other court in the world has justices who serve for life. And indeed, in the United States, the idea of exercising that much power for a lifetime is, as Kiko says, almost monarchical. We don't allow presidents to have more than 2 terms. It's the only life power that we give. And so to answer Michael's question would not only take me beyond what I promised the President of the United States as a member of his commission not to do, and that is to ventilate these things before a report is submitted to him and made public in the middle of next month. But it would require a very extended discussion, not only of theory, but of implementation. Now, having said that, I want to just seize the opportunity to agree with a number of themes that I hear across the board. When Gwyneth reminds us about de Tocqueville and the extent to which he emphasized the hyper legalization of America, the way we tend to transform social and political and philosophical questions into legalistic questions that only a certain elite with a certain lingo can speak about intelligibly, we risk undemocratizing ourselves in a deep sociological sense. That is, we risk disempowering people to engage in the kind of meaningful participatory dialogue about what rights should be, what constitutes a minority, who are the groups that are so subordinated that we need to be particularly alert to the danger of mistreating them. All of these questions are inherently political, although they are couched in legal terms. And the notion that is being propagated by a number of American jurists, including justices who are on the moderate to liberal side, like Justice Breyer, and justices who are more conservative, like Justice Barrett, that somehow the judicial priesthood engages in discussions only of principle and that these principles are inherently apolitical is nonsense. Most of us know, I'm sure the justices themselves know, that the line between law and politics is not only blurry, but incoherent. The question of what we mean by liberty, what we mean by personal dignity, however detailed the Constitution may be, it's ultimately going to leave a lot of these deep questions as questions about which there is profound disagreement, and in America today, even more disagreement than ever before in my lifetime. And to think that we can resolve them through any one institution is a mistake. It is, I think, a dialogue between an institution that aspires to be more principled, that aspires to give reasons for its decisions, although our Supreme Court has gotten into the habit of deciding things at midnight in the shadows and without reasons. But a dialogue between that kind of institution, which is appointed in a political way, but which is not directly politically accountable, even though many of its members hobnob with politicians, even if, Roberto, you manage not to do it, a dialogue between that kind of institution and institutions that are more overtly partisan, and hopefully a more educated public discussing these matters more broadly, is what we need. That is, we need an interactive, evolving dialogue about the meaning of liberty and the meaning of dignity and the nature of human rights in order to make progress. But I don't think that it's correct to say that a majoritarian institution like Congress can't be relied on ever to protect minority rights. As Nico points out, it was our Congress that in the wake of the Civil War protected minority rights all over the place. And it was our politically independent Supreme Court that dismantled those protections by invalidating the Civil Rights Act, and then now more recently, basically rendering impotent the Voting Rights Act. So the answer is all of the above. That is, we can't rely on any one institution. We can't assume that law is insulated from politics. We have to remember that what we do will affect the rest of the world. But when a commission like the one I'm on advises President Biden what to do, it really wouldn't do for us to say that the right thing to do is to shake up our court, make it bigger, put in term limits, but we dare not do it because the rest of the world might use that as an excuse for authoritarian measures. I mean, we really have to make our nation as just and as democratic as we can, because the Urbans of the world are going to do what they will do. They may use us as an excuse, but we would fool ourselves if we thought that by not doing what is best for the protection of rights in the United States, we will somehow protect the rest of the world from autocrats.
Okay, well, thank you for that, Larry. Fair enough that you didn't address my question directly, that you demurred. On the other hand, I would hardly consider your closing remarks non-committal. They were judicious and suggestive and penetrating, and really brought us full circle for what's really been an internationally informed discussion in the end of the fraught and porous boundary between politics and law. So on Kiku's behalf and mine, and really on behalf of the entire group, I want to thank Nico and Roberto and Larry for really a fascinating discussion that feels as if it's only just begun. Thank you all very much.
Thank you.
Thank you all. My pleasure to be here with you all.
Thanks.
Thank you.
Thank
Thank
you.
you.
This was really fun.
Meet you, Nico. All the best and good luck.
Likewise.
Bye,
Good luck.
everyone.